Department of Licensing and Regulation. Thank you very much for being here. Thank you all, the board members, for taking time and being here today. So let's go ahead and get rolling. So item B is a roll call. So David Aherons, he said he could not make it today. Randall Duncan. Present. Kevin Matthews.
Present.
Catherine Mize.
Here.
And then Catherine Pazkowski, she is absent. And then Sterling Phillips. Here. So we did make a quorum, so we can move forward. Thank you. Next is going to be the approval of the minutes. So hopefully everyone has reviewed those, and do we have a motion?
Kevin Matthews, I make a motion, we approve the minutes from the last meeting.
Randy Duncan, second.
All right, all in favor?
Aye.
Aye. All against? So moved. Next on the agenda is going to be the public comment. Did we get anyone to come for, so there's no public comment? So next on the agenda is going to be E, the staff reports, and the first one is going to be licensing division.
Good morning, advisory board members, Chairman Mojica. My name is Leonard Rivas. I'm with the licensing division. In your packet, I provided the licensing statistics since your last meeting in February. I won't go through all of them. I'll just hit some highlights. Since your last meeting, we've issued 38 new licenses, 27 renewals for individuals, and we've issued 5 new licenses and 16 renewals for facilities. And we had 2 new uniquely qualified applicants apply, and they're still in progress. And that concludes my report, unless you have any questions for me.
Any questions?
All right, thank you.
We're good. Thank you very much. Next on the agenda is going to be customer service.
Good morning, advisory board members. My name is Tuan Nguyen. I'm the customer service manager for this program. So since the last time we met, we have some new stats for February, March, and April. As you can see, February, it was a little bit slow that month. It lowered a bit from January, and then we had a slight increase from March and April. It's mainly due to the semesters being over, and a lot of people are calling in about their application statuses, application requirements, and then our team is just tracking most of them, and we're following up with customers to let them know what's the progress on those. But other than that, that's all I have for you, and I'll be happy to answer any questions you have for me.
Any questions? Nope. We're good. Thank you very much. Appreciate it. Next on the agenda is going to be Enforcement Division.
Good morning, Chairman Mojica.
Good morning.
Board members. Virginia Fields, prosecutor with the Enforcement Division. My report today is rather brief. There's one case since our last meeting for your case highlights. Actually, it's an important case. It's the last one that was transferred from the Department of State Health and Human Services. And essentially on February 20th of this year, we entered an agreed order with the respondent, North Texas Regional Orthotics and Prosthetics, assessing an administrative penalty of $2,250 for basically ordering a clear test socket for a patient in November of 2015, and the patient never received it. The respondent reimbursed amounts claimed on insurance, is in compliance with the agreed order, and has paid the penalty in full. I'm happy to answer any questions on the case highlight, if you'd like.
So this was a case, Kevin Matthews, this was a case of someone billing for a check socket that wasn't done?
Yes, sir. And they reimbursed the insurance company.
So is that not fraud? And there's
It was
no criminal-
unprofessional conduct, yes, sir. So that was the basis of the allegation. It wasn't, the allegation is under the rules, and it was for unprofessional conduct, unethical conduct. That's how the rule reads specifically under 114.90.
Catherine Mize. So just for clarity, they repaid the insurance company and then they were fined the additional $2,250?
Yes, ma'am.
$2,250 for violation, okay.
Yes, ma'am. Any other questions?
How many open and ongoing cases do we have?
In the key statistics, I was going to run
that's
through
next.
that.
Okay.
Yeah. We have, I'll move forward to the key statistics. For the fiscal year 2018, it reflects that 11 cases were opened and resolved. You'll notice there are 3 agreed orders. The penalties that have been collected includes that $2,250 that was on the case highlight. Currently, I checked this morning, we have approximately 10 cases open, some with our expert, some in investigation. A couple of them have just been received in intake, and then there are about 8 with the prosecutors. Like that. But there are 10 total currently with enforcement. And I'm happy to answer any questions on those key statistics if you'd like.
I think we're good.
All right,
Thank you very
Chair.
much. Next on the agenda is going to be Education and Examination Division.
Good morning, Mr. Chairman and board members.
Good morning.
How are y'all doing today?
Doing well.
As reports before you, mine's pretty brief as well. Before you, we provided statistics for the jurisprudence exam as well as the CE audits that we performed through the end of April 2018. Other than that, there's really not a lot to report from the Education and Examination Division at this time. If there's any questions you may have that I can try to answer for you, I'll be happy to.
Any questions? We're good.
Okay, thank you.
Thank you very
Appreciate it.
much. Appreciate it. Next on the agenda is going to be the Regulatory Program Management Division.
Hi, I'm Yvonne Feinleib with Regulatory Program Management, and
I'm Heather Muir, also with Regulatory Program Management.
as some of you may already be aware, I have a little email I'm going to send out. I've accepted a new position here in Regulatory Program Management. I will be covering duties until somebody new can be trained, and Heather is going to be one of the people who will help cover duties. So I wanted you to get to meet her. She is excellent. She's actually had O&P before at DSHS a long, long time ago, and she's going to help you with anything you need, and it's going to be fine. It's going to go really well. Really happy that she's the person. And then just on the report, the help that we provided on Dynamics 365, that is no longer going on. That's all caught up. We're not doing that right now. I don't know if you've seen the FAQs on assistance. If you haven't noticed those on our website, please go out and look at them. We are still providing training and discussion sections on a number of different topics. So licensing customer service can ask medical and health professions if there's something they would like more training on or an overview. They also get to ask questions every month. So we all come and are available to them so that if there's any program questions that they have any concern about, they can get information from us. And then we have the TDLR Health Monitor, our newsletter, and I assume some of you have been getting it by email. If you didn't sign up for it, you might want to consider signing up. And I'm happy to answer any questions. Or Heather. Heather can answer any questions.
Yes, I would just add to that I was actually the second executive director for this program back in the early to mid 2000s. So I do have a little bit of history with the program. Also, our manager for our section, Stephen Mills, will be retiring August 31st. We will miss him, and I will assume those duties on September 1st. So I will be the manager, and hopefully we will get someone super awesome to fill Yvonne's role. Big shoes to fill, I know. And I know y'all are aware of that as well, but we hopefully will be working on that soon.
And I'm going to miss all of you.
We're gonna miss you.
She'll still be around.
I was gonna say, we know
Heather
where
here,
she
she
is.
will still be around.
She can't hide.
Yes, I'll be on the 4th floor.
Email's going to be the same?
Yes.
So I just want to say thank you, Yvonne, for everything you did for our profession. It's greatly appreciated,
Yeah.
really.
Seriously, but
Mm-hmm.
excellent.
No questions? Next on the agenda is going to be the Field Inspections Division.
Good morning.
Good morning.
Hi, my name is Tanya Guthrow. I'm the Director of Field Inspections. And in our report today, we have a list of the most common violations that have been found during the second quarter of fiscal year 2018 during inspections. One important thing to remember is that these are violations that the inspectors may have indicated or noted, but they are not direct to enforcement. They're not all direct to enforcement violations, and so don't necessarily result in any sort of enforcement action. The inspectors do list them, and they go over how to correct any violations noted during the inspection with the licensees and help them get into compliance. If it's something very serious, though, they may have referred it to enforcement, and then the prosecutors will make a determination whether or not there's anything to pursue. And next, we have a personnel update. We've had a lot of changes and updates in our division just overall. We hired a new inspector, Sharon Hollins, in the North Region, and we want to welcome her to our TDLR family. Unfortunately, our South Region manager, Jennifer Hardless, has moved on to another new position, but luckily it's with the agency. She's going to be our Strategic Response Coordinator. And recently, it wasn't noted at the time, but we have hired from within, and I want to welcome Fernando Reyes as the South Region Manager, replacing Jennifer. And then we have our inspection statistics. So we've got our folks out there. We have an inspector in each region who is dedicated to performing these inspections, and we're fitting them in along with all the other inspections that we're doing. Any questions at this time?
Yeah, I just have one. Randy Duncan, on most of these common violations, are y'all doing a follow-up inspection to see if there's been corrective action, or?
We really don't do follow-up inspections on a regular basis. However, it is an option available to us, and I would say, you know, this is still a relatively new program, so a lot of what we're doing is just educating people on the process. The other thing to remember is that if there is a need or we feel like something is incredibly serious, then we always have that option to do a follow-up inspection. And we haven't with this program, but in the past with other programs, we do work with the enforcement division. If they, you know, get a case or a report and they feel like additional work needs to be done, we work in conjunction with them if they feel like the inspector needs to go back.
Kevin Matthews, I'm just curious, it looks like we have several inspectors, and I know you inspect other things, but we're averaging 11 inspections a month?
Yeah, it
And
is.
There's probably 100 facilities that haven't been looked at yet?
That is true, and you guys are on, I believe, a 2-year cycle for inspections, so it is something that we have to coordinate in. You know, the division, we actually have almost, not quite, 60,000 facilities that are required to be inspected once about every 2 years. So, yeah, it is a matter of fitting in these inspections.
Catherine Mize, on your inspection statistics, I think I'm just reading the chart wrong,
Oh, let's see.
because it looks like you did 7 inspections in September of 2018, which is in the future.
Well, you're right.
So I'm trying to figure this out. Is that, should that
Mary
just be?
Winston, TDLR. Sorry, Catherine. That's fiscal year 2018, so
Oh,
that's
fiscal.
September
Yeah.
of 2017. FY fiscal year. That's
right.
what it is.
Yeah, we're not on the calendar year.
I knew
Yeah.
I was reading something
Yeah.
wrong. Thank you.
It's possible, though. Keep looking for those
Yeah,
things,
yeah.
just in case.
We're human.
Anything else?
I think we're
All
set.
right.
Thank you very
Thank
much.
you so much.
Appreciate it. Next on the agenda is going to be the Executive Office.
Mr. Chairman and board members, Nick Bowinas, TDLR, and I'll be providing a little summary of what's going on around the agency today. First off, thank you for being here today and for your service. Wanted to report that recently Governor Abbott appointed 2 new members to our commission for terms that expire in 2023. So the board is back at full strength. The governor added Dr. Ray Callis, who's a physician anesthesiologist from Beaumont, and Dr. Gary Wesson, who's a retired orthodontist living in Bastrop, to our 7-member commission. We've got additional biographical information on our website for you. The commission last met on May 24th, and we'll meet again here on July 20th, and we're happy to have with us today the chairman of our commission, Mike Aris-Mendez from Lubbock. Also wanted to mention that we have recently completed our strategic planning exercise, and this is something that the legislature mandates all state agencies complete every 2 years, and it's something that we take very seriously, and want to stress that we encouraged all of our constituents to participate and stress that they had a voice in the process. We hosted external sessions in Arlington, El Paso, Houston, McAllen, and Austin. And these sessions were an opportunity for folks to come in and share ideas and opinions on how we're doing and how we can improve. And for those who were unable to make any of those sessions, we made available to them to participate through Facebook and our website. We also conducted internal sessions for our staff throughout the agency. And as I mentioned earlier, the final report, was completed last week and was turned into the governor and the legislative budget board, and it's going to be available today for the public on the tdlr.texas.gov website. Also want to talk a little bit about our outreach, including your website. Over the past 6 months, your site has had 8,567 page views, which is an average of 47 per day. 72% of those accessed the site from a desktop, while 20% did so from a smartphone and 8% from a tablet. The top reasons for visiting the site were, number 1, online licensing, followed by rules, forms, the law, and FAQs. In addition to the website, I wanted to remind you that we are active on social media through Facebook and Twitter, so if you'd like to keep up with TDLR news and activities, please follow us there. And also wanted to give you an update. We have more than 4,200 subscribers who receive various emails on your program. And if anyone is not receiving those but would like to, they could go to the website and subscribe to that. Thank you.
Any questions? All right. We're moving on to item F. And that's going to be discussion and possible recommendation regarding the proposed amendments to 16 Texas Administrative Code, Chapter 114, and then they're all labeled there.
Good morning, Chairman and Commissioners.
Good morning.
Board members. Today, our item on the agenda is to review the public comments from the rural proposal. It was published in the April 13th, 2018 issue of the Texas Register, and the public comment period ended May 14th. We did receive comments on the rules from one individual and from the Texas Medical Association, the Texas Orthopedic Association, and the Texas Podiatric Medical Association. And, of course, as you know, the rules as proposed, we can make some changes, limited changes for adoption. The main underlying theme here is public notice. If we make drastic changes, the public hasn't had notice of those, can't give comment and opinion about that. So we cannot make too drastic of changes for adoption. They have to be pretty consistent with what was proposed, not stretching that envelope too far. So as we go through the discussion of the comments, I'll be giving you a proposed response, and we can discuss as we go any changes that you'd like to make, or if you don't agree with the proposed response, we can decide whether that response should change and or whether any rule text should change. My proposed responses can certainly change. The more critical changes would be to the text itself. So I have summarized the comments, and so I'll just kind of recap those and then go through the proposed response. And if you've received copies of the comments, so you're probably familiar with those. But do let me know if you need me to read something from the comments. First, the individual that commented regarding the removal of the Texas residency requirement. The response to that simply is that that's a statutory change, that the legislature removed the requirement to be a Texas resident, and so there's nothing we can do about that. We just have to implement that, so I don't recommend any change to the rule based on that comment. That's a pretty cut and dried change. It's statutory change. The next comment is that 3 of the entities that commented said that the rules shouldn't authorize orthotists and prosthetists to have direct access to patients to provide services without an order from an authorized medical professional. And they commented that the provisions in 11475A, which is the new standard of care scope of practice type section, they said that that those provisions that allow for the initial consult and evaluation and preliminary measuring, scanning, and casting to be conducted by a licensed orthotist or prosthetist before the written order for an orthosis or prosthesis is received conflict with the law and therefore aren't permitted. The commenters stated that the amendments unlawfully expand the authority and scope of practice of orthotists and prosthetists by permitting access to patients and services to patients that are not under a medical professional's order. And they also raised concerns about license holders charging for unauthorized services, and some suggested text changes were provided. And I'll read you my proposed response, which to me is consistent with the law and with what your members have previously expressed, both in the board meetings and in the work groups. The Act defines orthotics and prosthetics as the science and practice of measuring, designing, fabricating, assembling, fitting, adjusting, or servicing an orthosis or prosthesis under an order from a licensed physician, chiropractor, or podiatrist, or an advanced practice nurse or physician assistant acting under the delegation and supervision of a licensed physician. That's a direct quote from the definitions in the Act. No other activities of an orthotics or prosthetics practitioner in the Act specify a requirement for an order. The definition of the profession of orthotics or prosthetics states that orthotic and prosthetic services include direct patient care, including consultation, evaluation, treatment, education, and advice to maximize the rehabilitation potential of disabled individuals. And again, that's a direct quote from the definition. Consistent with the Act, the rule does not authorize a practitioner to create or provide an orthosis or prosthesis without a written order, but it does provide specifically for other direct patient care services without specifying that the care may be provided only under an order. An initial consultation with a practitioner that is limited to measuring, scanning, or casting the patient requires the practitioner to be licensed, but the law does not require an order to perform these services. The benefits to patients when measurements, scans, or casting can be done during an initial visit are convenience and increased speed with which the orthosis or prosthesis can be provided, because the practitioner can proceed to create the product upon receipt of the order without requiring another visit with the patient. The department is not authorized to regulate what a practitioner may charge a patient or for what services the practitioner may charge, nor may it regulate insurance coverage for professional services. The department understands that initial and subsequent consultations with patients are typically included in the cost and coverage for the creation and provision of an orthosis or prosthesis. Practitioners are free to choose whether to provide initial consultation or services for which they may or may not ultimately recover payment in advance of receiving an order for an orthosis or prosthesis. The department has made no change. That's my recommendation, is not to make a change to that proposed text. And basically my response is that I felt like the language was consistent with the law, and that, if you provide these initial services when they walk in the door, you're taking a risk that you're not going to get paid, because our understanding is that you don't get paid unless an actual orthosis or prosthesis is created under an order, and that's the point at which you can actually charge for those services. And so I felt like, I didn't say this in the draft response, but that I think you'd be dishonest with the patient if you didn't tell them, if you said, well, your insurance isn't going to cover this, but I'm going to charge you, or something like that. I don't think, my impression has been that you all don't charge for that until you actually have an order, and then you create a product for them, and then it's all encompassed in that charge. So if you'd like to discuss, the text or the response, this is the time.
Kevin Matthews, I think the response was perfect. Sounded good to me.
Miguel Mojica, I'm thinking the same, and the way you're describing exactly correct, that we do take a risk when we decide to take an impression without that order, knowing that potentially the doctor will say no, or something will occur where we then have lost, time and in some cases some material. But I think when we decided this was something we wanted to change, that was a part of it. So yeah, at least where I work, there wouldn't be a charge for that until that product is delivered to them. So
Yeah, and it doesn't say it in the rule, but it says the initial consult. Well, it doesn't say that the person has to have had an orthosis or prosthesis before. It could be a new patient who knows nothing about it, walks in the door and starts asking questions, or it could be someone who already has one and maybe comes in and says, well, it's not working for me. What do you think? Should I get an order for a new one or something? And naturally, our feeling is that all of this requires a license, but under the statute, the order is not required for you to talk to the patient and have those initial discussions. An analogy was made to a pharmacist that you can't go in and a pharmacist can't order you a medication, but a pharmacist certainly can talk to you about medications and interactions and all of those sorts of things. They have to have a license to do that, but they don't have to have an order. And so I think, my impression from you has been that that's a dividing line that you understand and practice every day. So I think unless you did want to change anything, I think we're okay on this text. But
Sterling Phillips, I agree 100%. This makes it a lot clearer for me. I understand, because I've been around so long, I'm going to tell them what I think anyway, so I like to hear it's legal. It makes me feel a little better.
And I think that's part of the reason this scope of practice was inserted into the rules, is because you all want some certainty and,
Right.
you want it in black and white, what you can do and
And,
can't.
you know, we know we're risking if we say, hey, let me measure you and we'll hold it until we get approval to save you a trip from Colorado or whatever. We're risking, but, I think we ought to try to help the patient as much as possible.
Well, I would recommend, we'll go through the rest of the comments and responses, and then if we want to revisit any of this, we can come back to it, just to keep moving.
Catherine Mize, I have a comment.
Uh-huh.
One of the things that I was involved in some discussions with, and I think you got through to this point, did you make it to, the written request for consultation in the facility, the healthcare facility? I'm on page of our documents given to us, I'm on page 11.
Of the proposed rule? you mean, or-
Yes, 1, 2, and then AB. 1 starts with accredited orthotic and prosthetic facilities practitioners may perform.
Oh, okay, so this,
Did you make it that far when you were reading to us? I'm sorry.
you're talking about the 11475A?
Yes,
Yeah.
yes.
Yes, I was looking at the proposed changes there.
Okay, one of the things that we were after in 2, where it starts with other facilities providing healthcare and rehab, or do y'all see where I am? On
Yes.
page 11? You got it, Mike?
I'm good. Go ahead there.
And this was the part that we were trying to prevent a sales rep or a representative or a prosthetist, it doesn't matter, somebody from an O&P company walking into a new patient's room that's undergone an amputation and trying to give them information about being an amputee or about going under their care without being asked to come and talk to that patient. And so that's why we wrote this section, is we're saying that we want them to have in essence, an order, an invitation to come in and visit with that patient. It was suggested to me, and I agree with, that any order or request that comes out of that hospital or rehab hospital ought to be directed through the treating physician. He is coordinating the care, she is coordinating the care of that patient while they're in the hospital. And one of the things that we included in here was that a physical therapist could initiate that request. And the physical therapist is a part of the team working under that doctor. And so it was suggested that we remove the word physical therapist and other healthcare occupational therapist and just bring it back to the group that can write orders, period. Because they're the ones coordinating the care in the rehab or the hospital. And so if a request needs to be made for the patient to be seen by somebody like us or from our company, it just needs to be directed through them so they know who and what information's being given to their patient while under their care. And I don't have a problem with that, once that was kind of pointed out to me and described. To take it a step further, I described the fact that we were trying to prevent the solicitation perhaps from the nurse that's feeding new patient information to the outside salesperson, or something. Now, they're violating HIPAA, obviously, but we're trying to circumvent that as well. So when I pointed that out, it was suggested that we remove the wording of self-referral. Because again, if the patient requests to talk to somebody, the patient ought to direct that request through their treating physician and get the physician's okay or blessing and have him generate that request. So just to continue the scenario, you've got a nurse who's feeding, or a hospital personnel person who's feeding information to a sales rep that works for an O&P company. That hospital personnel could walk into the patient's room and say, hey, I've got somebody that can talk to you about needing a leg. All you have to do is make the request. So we really haven't circumvented anything. But that we might have better success if we attempt to say that legally it all needs to be funneled through the ordering physician. Or nurse practitioner, or chiropractor, or, in other words, the group of people that's already been designated as legal to issue our prescriptions.
Well, right now, the rule, as proposed, it says that the orthotist or prosthetist can perform the initial consult for a patient in a facility providing health care, rehab, or therapy, only pursuant to a written request for consult for that particular patient, signed by a member of the healthcare team for the facility, including the doctor, the healthcare professional, physical therapist, or occupational therapist, or it can be a request initiated by the patient or the patient's representative before any consult is performed. And this was created to be in step with the predatory practices that are prohibited in the occupations code, where you can't be soliciting patients and paying people to go visit them. So this put it in the position where there had to be a request, either from the patient or the healthcare team. I think you're wanting to extend this to that it all needs to be through the physician, and we can't regulate what people do. We can regulate orthotists and prosthetists, but we can't regulate the patient. And the patient can get on the internet and look these things up, the patient can do it with whatever they want.
Correct.
We're saying orthotists and prosthetists, you can't go in that facility and start talking to people if they haven't asked for you to be there and talk to them. So I'm not sure if you want to go down the road of imposing more restrictions or not, but if you do, then that kind of change would have to wait. Either have to not make this change or leave this change as is and then further refine in another rulemaking, because the public won't have had notice that you're becoming more restrictive that way. So it's sort of a decision to leave it as is, not make the change at all, and go to another rulemaking in either case to
Okay.
refine it.
Okay. All right, so this, in other words, this is too big of a change to make within this rulemaking process right here.
Yes, at adoption, you really can't make major changes like that where
Right.
you haven't gone through the public comment process, so that would be a concern. And if you feel like the provision as written is too broad, that's fine, you don't have to make the change, but it is protective, at least to some extent, more than what the current law says, because all we have right now is the statute on this. We don't have anything in the rules yet until this is adopted.
Right.
So, and this, in my opinion, is consistent with the statute, which, the statute is silent on a lot of things, and so we're developing this, interpreting the statute and not being in conflict with it, but it's not like you're going to find a specific provision about this in the statute, so there isn't any conflict, but as you're saying, you may want to be more restrictive. You may want to do this as a first step and then refine again in another rulemaking, but
Okay.
you really need more public input and that to be able to make that kind of change.
Okay.
Kevin Matthews, so what we're saying here is you can't do a consultation in any physical therapist clinic, any healthcare facility, period, without a written request for consultation.
I don't believe it's all written, a written request from the team, one of the healthcare providers there, basically, which could be a notation in a chart, a request. It's not an order. It's not saying an order, just a request. They have to have requested the person to come to the facility to talk to the patient, or the patient can do it. And the patient, it doesn't have to be in writing for the patient.
So, but this applies to any inpatient, outpatient therapy, a dialysis center, any medical practice there is, you would need a written request to go in and talk to that patient or do anything.
Yeah, from the facility or from the patient themselves, which could be a phone call. It doesn't have to be written from the patient or the patient's representative. which, you know, this is actually imposing a restriction that wasn't there in the rule before, but it's meant to be protective to prevent, you know, the patient in the bed being deluged with, you know, people coming in and trying to sell services, or, you know, that sort of thing. So it does protect the patient. It's consistent with the Act. The Act doesn't really go into this, but.
So the act doesn't cover a sales rep for, say, my company. Say I have a company and we do prosthetics, and I've got someone in the hospital that tells me whenever there's a new amputee, and I make sure my sales rep stops by that room and tells the patient, hey, I just wanted to let you know that, you know, I represent an orthotic company and we're here for you if you need us. Here's some information. And they leave. Well, that person cannot be punished through this, our statute, correct?
Well, and what you're getting at is more of the predatory kinds of actions
Sure.
that are prohibited in the Occupations Code 102, which is, you know, preventing people from doing that sort of thing, soliciting patients that way. So it might fall under that. It would depend on the facts of how they were soliciting and approaching that person. But with this in there, yeah, there'd have to be a request. They couldn't just go in there cold and start soliciting a patient.
So I filed a complaint on a person that outside of a dialysis center directly approached the patient, gave them a business card for their prosthetic company, and said basically that they're the only ones that can do the work, they do the best work, blah, blah, blah. I filed a complaint, and they said that's not illegal. So what you're saying is it is illegal under the Occupations Code? So, in other words, direct patient marketing is legal, correct?
The, I don't know if I have the language in front of me. Can you pull, yeah, the Occupations Code language.
Pull it up.
Kevin, Catherine Mize, it's my understanding that this language would not stop that direct example that you just gave outside the dialysis unit. That is not a patient that is an inpatient or in that dialysis unit. They are outside, they're going home. I was on the team that helped write this language, and now I'm second guessing what I helped write and what we wrote. What's bothering me is I would like to see the new amputee in the hospital protected from direct marketing. That is the intent of my protection. It is not my intent to stop a physical therapist in their own facility from saying, hey, Kevin, come over and take a look at this kid. And it doesn't, because the way we have it written right now, even that physical therapist could make a written request for you to come.
Right, and that's easy enough for us to do, and or I
Easy
could
enough
fill it
to
out
do.
in my office and have her sign it when I get there, you know, whatever.
But if the patient is an inpatient in a facility, in a hospital, in a rehab, and I'm specifically thinking about the patient that got hit by the car on the side of the road and is in the hospital and is 4 days post-op from losing his leg. I don't want that person direct solicited by ABC O&P company.
Yeah.
And I don't want a unethical hospital personnel person feeding that information to somebody and letting them come in to talk to them. So I'm stepping back from this exact language and saying part of it maybe should be more restrictive than what we've written, and a portion of it should be less restrictive than what we've written. I just think it needs to be tweaked a little bit.
In my opinion, it's vague and can be misinterpreted. I know for a fact in San Antonio, we've got a group of doctors who have their own prosthetist, and they will not sign a prescription or a referral to any outside prosthetic facility. And the doctors tell the patients directly, if you want to go see another prosthetist, find another doctor, period. You see our prosthetist or you go see another doctor.
But we can't change that, Can we?
So, but I mean, if
We don't regulate
but
them.
if we start saying that it has to be signed by the physician that's taking care of their care, and that physician only works with this company, so nobody else can get in. Physicians have biases. They may have biases. So, to me, this, well, I understand the logic behind it and makes sense because there are predatory prosthetists and prosthetic companies out there. They've been there forever. You can go into a patient's room who's a fresh amputee and almost guaranteed they're gonna have 3 business cards within 2 days from 3 different prosthetic companies that happen to stop by their room.
Do you want to shut that down?
It would be nice, but I don't know how you can do it and focus it specifically to that case and not generalize throughout orthotics and prosthetics as a profession. It'd be nice if we could in a way, yeah, I absolutely want to shut that down.
Did you have some
This is.
language that you wanted to?
This is the Occupations Code, which is cited, Chapter 102, and this is Solicitation of Patients is the name of the chapter. And it makes it an offense if a person knowingly offers to pay or agrees to accept directly or indirectly, overtly or covertly, any remuneration in cash or in kind to or from another for securing or soliciting a patient or patronage for or from a person licensed, certified, or registered by a state healthcare regulatory agency. So, you know, it goes on with more detail about, you know, the ins and outs of that, you know, when you are soliciting and not, but it would be a factual matter that our enforcement process would have to show that the person basically was paid to go solicit patients. So you're not always going to get to this point where you can show that they were paid. You're trying to get at solicitation, paid or unpaid, where the patient didn't ask for it and no one else asked for it at that facility where that patient is residing. So
The person making the solicitation is being paid.
Right.
They're an employee of the company.
Yeah,
But
so,
but it's been my understanding that the application of what you just read in the situation that we're trying to address is not a clean application. It's going to be something that's very difficult to prove and enforce or prosecute.
we've tied in the, you know, this into the rule in, on that page 11, kind of a little lower than the middle, where it says, practitioners shall prohibit any person affiliated in any way with their practice or the practice of an accredited facility for which they serve as practitioner in charge from providing or attempting to provide a consultation in violation of this chapter, these rules, or that's prohibited by the Occupations Code 102.001 that I just read you, soliciting. So, and, you know, you have in here, as we've just been talking about, these provisions that say that the person can't go in there and solicit without a written request or the patient's request for them to be there. So that would cover any request, however they're paid. They're not supposed to be soliciting unless they have that request. This is going to cover, it's a criminal offense to solicit for money to get patients. So, but if they violate this, they would be in violation of the rules. You just have to, you'd have to prove this occurred where they were paid to solicit. You don't have to prove that they were paid. If they solicit under the rules as they are right now, that would be a rule violation if they're soliciting without a request.
So back to what, the point you made earlier, if we were to make that a change now, we'd have to send it back for public comment.
Depending on what
Depending
you
on-
wanted to change. Now, you were saying they're more strict in some ways and less strict in others, so if you wanted to maybe back off on the stringency on some of that, that might be okay. If we want to make it more stringent, then that would be more troublesome for public comment and response.
So if we
So-
remove physical therapists or occupational therapists, we're making it more stringent.
Yes.
So that would
So
send
our
it
option
back.
is to leave, to not make the change at all in that particular case, but go back to the original, or leave the proposed change as is and let it go through that way.
Right, you could leave it as is. You might, since there was nothing before, it would just be
Mhm.
gone and there is no
Yeah.
provision about it. We just have the occupations code where it's a criminal offense to solicit.
So I don't want to abandon this by any stretch of the imagination.
Mhm.
I don't want to abandon it, but I am wanting to revisit some of this wording.
Which I think the whole document can be revisited.
Which
the
section
question-
specifically?
The part that I was talking about,
In A?
referring to the patient in the facility, in A, and then, what was the other part? The initial consultation, I'm not finding it right here. Laura, where's the other part that the comments that I sent you are dealing with?
Well, you had sent me a paragraph replacing or modifying A, and then, let's see.
Oh, I guess one. It's modifying one. The initial consultation, evaluation, preliminary casting, measuring, scanning.
Mary
That was what the other-
Winston, TDLR. Catherine, I'm not sure that, I know you and Laura have that language. The rest of the board does not have that language.
Right.
So, Mr. Mojica, would you like to take just a little break so everyone can be on the same page and get that language?
Yes.
What language are we missing?
There is language, I don't have it either, but it is, Catherine has been talking to Laura, and she had some suggested language that they are addressing, referring to right now. We don't have it. So if we just take a little break, we can all get on that same page, if it suits our presiding officer.
That'd be great.
5 minutes?
Yes, 5-minute break.
Thank you.
Uh-huh. We now have the information that Catherine had passed on. And did you want to make any comments, Catherine?
Yeah, real quickly, at the very beginning, the first yellow highlight where it says follow-up patient consultation, and you see the words repair of an existing device, strike that. That was a note that I was making to myself, and it appears later in the notes. So that needs to be, that's not under consideration in that location at all. The first paragraph of yellow highlight that you see, there's some comments on the side that are from Texas Medical Association and Texas Orthopedic Association. But the essence of that first yellow highlighted area that's number 1 is that they would like to see some language that mirrors physical therapists, and that basically if we have an order that's 12 months old or younger, that we can in essence do just about anything we need to for that patient without question. If the order exceeds 12 months, they're suggesting that we need to get a new order. We have to, as we know, get a new order to be able to bill for that device anyway. And then they wanted to put in the practitioners may not charge for the patient's consult. And Laura has already responded to that and said that cannot be regulated. And I don't think it needs to be regulated. The association's point here was that they didn't want to see patients charged for a service that was never going to be able to be done anyway. So if somebody did an unethical consultation and casting and charged the patient knowing that they were never going to get the order for that, they felt like that was deceitful. But I just don't think that's going to happen. And like Laura said, I don't think it can be regulated.
And there's
You
no
said it
code to
couldn't,
bill
so.
for that.
So that's,
Well, right now, the statute, doesn't address these specifics. It just doesn't.
okay.
And so my caution is, don't tie your own hands if the statute isn't tying them. If it's 1 in a million that it's going to happen, maybe it's not worth trying to regulate that.
Right.
Right. And we can always change the rules. We can always tighten them up or loosen them up as we go. I felt like, this was a good start. It gives the outlines of where you can do what, and it's useful to look at it that way and try not to conflate all the factors. It's where you can do certain things, how you do it. Do you need an order to be there? What you're doing? Is the patient new or an existing patient? Have they had an orthotic or prosthetic before or not? These are different things that you can separate out, and you can try to regulate what an orthotist or prosthetist can do depending on those factors. I'm not so sure it's useful to make distinctions between an established patient and a new one when you're, giving them a consult. I mean, I don't really see a reason why you'd want to impose that and make some distinctions about existing and not, other than that the existing patient probably had an order at some point because they had an orthotic or prosthetic made. But like you say, the law would require a new prescription after a year anyway. Do we really gain anything by putting it in your rules? Maybe not. I've already explained we can't make a lot of changes at adoption. We're at the point where we can't change a lot.
Right.
If you can live with what's here, maybe with some minor tweaking, and go ahead and adopt, it can always be refined. Or you can leave it out completely and just rework the whole thing in work groups, comment again, do another rulemaking.
And this is Brian Francis. Let me just offer this, that I think what we're talking about here is trying to make sure that other groups that are affected by this industry, or maybe have some comfort that that you're not going too far. And it sounds like you've had some good conversations with those groups, and their distinction on existing versus a patient they've never worked with. I don't think it throws a monkey wrench in everything. It just defines that you got an existing relationship and allows for it. I'd like for us to maybe think about all three of the options. As Laura laid out, we got the option of going with the language as it is, maybe 4. We had the option of tweaking some of it. We had the option of looking at these elements here, because I think they fall within the groundwork of what we put out there, or holding it back. So I'd like to keep the dialogue open and have you really fully discuss what this looks like on a day-to-day basis and how it feels. It looks like it fits within the concepts that y'all initially laid out. It just gives a little bit more granularity to the distinction between who is existing, who is not. But at the end of the day, we all know you're not going to do the casting and those things until you have an order. Doesn't matter what the dynamic is. So I think it's just comfort language to some people.
Kevin Matthews, that's not my understanding. Previously, this was brought up, and we could do a casting without an order.
No,
You could never do it.
no. According to the act, no. I'm sorry, I'm speaking out. Turn.
Well, no, that's fine. So if a patient comes in with a broken AFO, it's over a year old, patient still needs it, needs to be replaced, so you cannot do the casting without. Because I've brought this up before in this meeting and was told that, yeah, as long as you don't provide any service that's going to be billed, it's okay. That we can go ahead and get the model of the patient's leg and hold it. That way that we don't have to schedule another appointment, get the patient back into the office. I'm incurring the expense to going ahead and getting the model and telling the patient we'll need a prescription to go any further. So get the prescription, have your doctor fax it over, or you can drop it off, and then we'll proceed with verifying insurance and all of that. But since you're here today, you obviously, the cracked AFO cannot be repaired. So we go ahead and get the mold and wait on the prescription to proceed.
And that's the difference between you being an expert and me being a novice. So the distinction, the line I typically draw is that you can't begin the fabrication of that.
Correct. But you can go ahead and get the model.
You can get the dimensions and what you need
Correct.
to expedite
But we
that
don't
process.
do anything because we can't bill for that service. So, like I have physical therapists routinely send me a patient. Kevin, I've got a little girl, I do a lot of pediatrics, I'd like you to look at, I can't decide if an AFO or an SMO
Sure.
is indicated. And 99 times out of 100, that therapist is gonna say, what do you think? I'll always call the therapist and say, there's some tone there, we really need to make an AFO.
Sure.
After I see the patient, but I'll go ahead and mold that patient, knowing that I'm gonna be providing service to that patient, or not, but I'll go ahead and save that parent another trip and take the mold of the patient's foot, and then I'll call and talk to the therapist. I really feel like an AFO is indicated. I never initiate the prescription. Then the therapist will initiate the wording, send the note to the doctor recommending the AFOs, which I never do, but the therapist does, and then we get the prescription, and then we proceed with the rest of the process, and the patient comes back for delivery after everything's been approved and done. And to me, that just makes sense. I'm not doing anything to harm that patient. I'm not doing anything
You're not
that
charging
I'm
them.
going to
Yeah,
bill that
yeah.
patient for. And the patient is, if the patient says, well, no, I don't want you to do that, of course you don't do that. But the patients are always like, well, good, thank you. So I don't have to take another day off work. I don't have to take my child out of school another day. If you can go ahead and get the measurements or get the model today, that's never a bad thing, in my opinion.
I think,
I think you're right.
Mary Winston, I think what we discussed earlier, and I don't know if you said it, I think we used the word risk. It's more of a business decision, because you're not charging for that. That is a business choice you're making.
It costs me money to do that.
It costs you make money. You may not be reimbursed if they go somewhere else.
And it happens.
That's right, so.
It happens. We find out that they have a huge deductible, they can't afford it. We throw it away. There's no bill.
Well, the rule as proposed authorizes the preliminary casting, measuring, and scanning of the patient.
Right.
It does not authorize and can't authorize creating the orthotic or prosthetic.
Correct,
It-
and that-
it-
just
you know,
something was
it's in
said-
there.
Sure.
The dividing line is measuring, designing, fabricating, assembling, fitting, adjusting, or servicing an orthosis or prosthesis under an order. That's what you have to have an order for. If you do preliminary scanning, casting, and measuring of a person, and there's no orthotic or prosthetic being created at that point, you don't need an order. You need to have a license
Correct.
to do that, but you
Okay.
don't need an order. That's what your rule says right now.
And that's, Brian said something different just a minute ago and said, well, you're not gonna cast until you actually
Well,
get the
yeah,
physical order.
and maybe the interpretation is casting.
Yeah, and
the part,
that's
but
Brian
it's not
admitting, again, the late
Right,
terminology.
So it's all good.
Call me Michael Jackson, I'm
Yeah,
moonwalking
I
away from
agree
that
with-
statement. I'm just
I agree
moonwalking
with
back.
what- Thank you, sir. And I agree with what you just said.
Yeah, I mean, you know, the rule doesn't go into, well, the patient may never come back, the patient may go somewhere else, you may decide you can't make, you know, those are things you have to exercise your judgment under your license as to whether you want to make the risk of doing that work, that preliminary work. If 9 times out of 10 it's a convenience to the patient, they have to come back, get measured again and cast again, you know, you don't have a problem with it, the rule doesn't have a problem with it, it's authorizing that, it's saying you can do that because it was a question, where's the dividing line? The statute draws a dividing line. What you do to create a prosthetic or an orthotic, that requires an order, and I think you all knew that, and you just wanted to make
Right.
it clear in the rule, and that's why it says what it says.
Right.
If you think it's too stringent or too loose, like I'm saying, we can make some tweaks on this, but we can't make a major change. And, you know, my recommendation is if you wanted it in black and white, go ahead and adopt the rule and then tweak it down the line. But if there's something you can't live with in it, then we can look at, you know, that, and maybe be able to tweak it.
Catherine Mize, Laura, I've got a question for you on number 2, where we're talking about other facilities providing healthcare, rehab, or therapy. Could we insert the wording, other facilities providing inpatient healthcare, rehab, or therapy? That points to the patient, as I described earlier, that is in the hospital, under the care of a healthcare team, under the care of a directing doctor. The way it's written right now, it could be an outpatient rehab, it could be a privately held therapy, outpatient therapy center, it could be anything.
So in number 2, what you're saying is other facilities providing inpatient health care. So could we add just that terminology?
Yeah,
That would make more sense to me, and that way we're not taking every possible healthcare
facility.
clinic
Yeah,
out there and narrowing it to inpatient care, which is where most of this stuff takes place. That would make more sense, and I would agree with that change.
Randy Duncan, let me ask a question. If we just make a few tweaks to this and propose it for adoption, it could still get kicked back by the commission, correct?
It could. It could, even if you don't make any changes right now. 'Cause
Yeah.
the commission hasn't seen it yet, so, you know.
The reason, Brian Francis, it would be kicked back if the commission tried to change the scope of practice element. That's the provision that says, you know, if there's a scope of practice provision and the commission says, oh, we're going to change that, then it does come back to you. They can't modify it and move it forward, so that would be a good thing if they decide, you know, basically, your work would not be changed to your detriment. It would always have to come back for you to rework it, so it's not a bad thing.
I just have 2 comments about adding the word inpatient. First, in favor of that, the wording already says for a patient in a facility, so the impression there is that they are a resident in that facility, that they are an inpatient. I don't know if that's exactly what was intended, but that is what it says right now. Practitioners may perform the initial consult for a patient in a facility. So if you add in the title, other facilities providing inpatient healthcare, rehab, or therapy, it's not really inconsistent with what the rule says right now. But the other caution I would say is, you know, are there a lot of different interpretations of what inpatient means? There could be. But arguing again for the ability to make that change, the headings of the sections are not law. So they're more informative than they are prescriptive. So if you add inpatient there, it doesn't change what your rule is saying, but it is clarifying.
Right.
So,
We should be good.
yeah, I mean, it's your call, but,
So that's one, if we're, what's y'all's opinion on that?
I like it.
Everybody okay with that, maybe?
I am. I like it better than the way it is now.
Okay.
It clarifies it to me. Because in a facility doesn't differentiate, it could be in an outpatient facility. I would say that just further clarifying.
What are your all's thoughts about clarifying that if they are inpatient, that any kind of request is directed through that doctor instead of any member of the healthcare team? What's your opinion on that?
Personally, it's sometimes very difficult to get a doctor. Usually a doctor that's in, say, a nursing home, it can take a month to get the detailed written order back from that physician because they're spread so thin, they cover so many.
I'm not talking about the detailed written order, I'm talking about a quick
But just
notation,
to get,
a
to
chart
get
to say
even,
consult.
to get even a quick notation, a detailed written order, they don't have to write, all they have to do is sign it.
But keeping in mind that our intent here is to limit that solicitation.
Correct, but I would say that if a person in the facility, a nurse, a physical therapist, an occupational therapist, if they contact you for a patient saying this patient needs care, that makes sense. There are some bad apples out there, but to require it to be a physician, it can be very difficult to get that patient to get back into that facility and do it, or get that physician on the phone, because they're managing hundreds of patients oftentimes in these facilities. And I think if we do change it to physician, that would be for another day. Let's approve that minor change and then address only the physician can do it, but I would disagree with that.
Randy Duncan, I think the key thing here is getting a written request. If it's any member of the healthcare team, I think that's good enough. You need to have a reason, a documented reason to be in there.
And that should be in our patient's chart, a copy of that stating that I went and saw the patient at this person's request, and that should be a part of the patient record in our facility.
But I agree, I don't want people just wandering in off the street and saying, hey, I heard you had an amputation, here's my card, here's a packet of information. The other side of that is, there are collusive agreements with facilities that keep us out of the loop and deny patients care that they might be able to get somewhere else. So I don't want to eliminate the ability for somebody else to come in it. Now, a hospital, to me, a hospital is a private entity. I'm not just going to walk into your grandma's house just the same way I'm not just going to walk into a hospital. I would say we'd put that more on the hospital, keep their house in order. If they've got people just wandering in off the street, that's something they need to handle themselves. And I don't think, I think this at least gives us one level of, is this rules or statutes?
Rules.
It's rules. So this establishes a rule that at least gives us something to fall back on when somebody is soliciting, walking in off the street, handing out business cards to everybody missing body parts. Am I wrong in thinking that?
well, and you can't control the world. You have no authority to control what a hospital
That's
does.
what I tell my kids all the
or
time.
it's-
The only person you can control is you.
Right, and we can only regulate what the orthotists or prosthetists can do. And if there's a requirement, they have to have a written order. They said, hey, I had an order. You don't have to have, educated the patient that there are 15 other firms out there that could do the same thing. People get on the internet and find that out anyway. There's free information now. You can regulate what an orthotist and prosthetist can do. If they need this request, you may not be able to police the arrangements that are going on and the under-table things. Now, there, you know, we do say they need to comply with the non-solicitation, and so, you know, we can always wrap that in if we feel like there's some fraud going on, but, you know, there are limits to what we can regulate, and you're putting a basic requirement to have this written request so that people aren't in there just going in as opportunists to, like what you're saying, you know, if someone's injured. I think it's a good first step for protections. I would urge caution on how far you try to regulate that, because then you're going to be getting into areas you may not be able to control. But I felt like this is a good first step, and it is consistent with the statute. The statute, it doesn't prohibit or allow any particular practices here, even though we do have the Active Patients Code making it a crime to solicit. So it's consistent with what the law is already hinting at, that you don't need to be doing these things. But, you know, in regulating your own profession, it's always a good thing to take steps, you know, and not be too drastic on the first pass. And this really is the first pass. This is the first time we've had scope of practice requirements in these rules. So it's, you know, whatever you do now to adopt, you're going to be living with the consequences, basically. If you want to put a foundation and build on that later, or if you want to get really stringent to start, you know, that's what you're going to be working with, get down the line.
Mary Winston Tubular, and y'all's general counsel has made some very good statements. It's not a final, it's a first pass, and it is, you don't want to restrict yourself into a hole. So how this is going to go forward with this first pass, you could give it time to do that without trying to really go back, scratch this rulemaking. This is, I'm hearing that this is a good thing, that we're moving forward. It just may not be enough, it may not be, but it's a first pass.
If you'd like, we can go on through to the other, I only have, like, basically, there's 4 comments, so.
Yeah, let's
we
move
could
on to the
go
other
through-
comments,
We can revisit
and
if we
then- yeah,
need to, but
we
right
can.
now, we've agreed on adding the term inpatient, I think, in the title, so.
Okay.
Okay. The next comment was that the 3 entities commented that the provisions in 11475F allowing orthotists or prosthetists to perform diagnostic fittings should be removed because diagnosis is not in the scope of their authority. And this is, let's see, let me find the exact word.
So Kevin Matthews, I just think we should get rid of that term diagnostic fitting, like Catherine also mentioned. It should be a test fitting or something to that nature, because it does, to a layperson, it looks like we're doing something to prove our diagnosis, which is not the case. We're doing that to determine whether or not
We did a good.
this
fit on
worked. Yeah, we did a good job. This is not a diagnostic fitting that we're doing, it's a test fitting. So we should just change that term and not use it anymore.
Yeah, and my response basically was to substitute an explanation of what it is for the term diagnostic fitting, since we didn't define it, and there doesn't seem to be an agreed-on definition out there on what diagnostic fitting is. So right now, it says all fitting, including diagnostic fitting and/or delivery, requires a written order. The order initially may be provided verbally and documented in the patient's record. A subsequent written order must be obtained promptly. And my suggestion was just take out diagnostic fitting and say something like this, and you can tweak this, but all fitting, including adjusting, aligning, or modifying an orthosis or prosthesis for the needs of a specific individual and/or delivery, requires a written order. There may be a better way to explain what a diagnostic fitting is that could be substituted there. and without offending the, rulemaking guidelines of not changing it too drastically. One of the recommendations was to replace the term with test socket, but again, that would be another term that isn't defined yet, and maybe that's.
I would just say test fitting. I mean, then we're just testing whether or not the device that we made is,
Gonna work.
yeah,
There would be scenarios where you do a test fitting for an orthosis.
right,
Just-
because it's not a test socket. I don't do sockets, I don't do prosthetics, but I do test fittings.
What do you think, Catherine?
I'm okay with that. I think that'd be
But there wouldn't need to be a definition for the word test, would there?
Well, it's probably more understandable to the average person than a diagnostic fitting.
Because we're not supposed to diagnose.
Right.
So that just says, well, we're confirming our diagnosis. So we shouldn't have diagnosed in the first place. So I would say get rid of that term altogether, and
Can fill
because
out-
that's gonna set doctors off if they think we're diagnosing. We diagnose every day, but we tell the patient, you got foot drop. It's obvious you have foot drop, but the doctor has to confirm that. But we're not able to actually physically diagnose a patient.
Right.
So diagnostic fitting is,
Sterling Phillips, I feel like we need to do away with the word diagnostic completely and stick with the word test fitting or test socket, depending on the office we're in. Because we all know what we're talking about when we're talking tests, so can we just accept it the way you've written it here, including test sockets and fittings and?
Or Catherine Mize, I think just saying including test fitting, because that way you can cover test sockets prosthetically, you can cover a orthotic test fitting.
I have no problem with that.
It's comprehensive with
I just write
lesser
test
words.
socket in my paperwork, so.
Right.
Randy
But you
Duncan, would
wouldn't
it be
for
more
orthotics.
appropriate to put trial fitting?
Oh,
that would work also.
I don't use the word trial.
It doesn't matter what we use personally in our practice, it matters what we put on
Yeah.
paper here.
Well, yeah, I mean, this is the issue, why, we're having these comments about diagnostic fitting is because it's a term that's in there, and I think y'all agree on what it means, but we don't have a definition, and so
Right.
then it's this hot term, this diagnosis. Well, no, you don't diagnose, and you can't under your act, but we don't want to throw in another word that is going to create a problem. If you say test or trial, maybe, or
I think either one of those words would be fine, and I can tell you the doctors don't object to the word test fitting at all.
So can we change that?
Yeah, just take socket out.
so do you want to say just test fitting, or test or trial fitting, or?
Test fitting.
Test
Test
fitting.
fitting?
Yep.
So it's going to say all fitting, including test fitting and/or delivery, requires a written order. You think that covers the scope of what you're talking about? And the next comment, last comment, is two entities raised concerns about predatory practices by license holders if services are performed in a patient's residence or in a facility under 11475, which is just the new scope of practice section. And my response is basically that they're protected from predatory practices by the Occupations Code, which makes it an offense to solicit, and also the provisions that you're just adding now, preventing solicitation in a facility without a written request or a request from the patient, that these things are addressing that. And the rules do make it an administrative violation to commit the criminal offense of solicitation, so it wraps that in. Let's see. And I just sort of explained that practitioners can perform consults or services at locations away from the accredited facility only in accordance with the Occupations Code 102 anti-solicitation, and as applicable on prior request from a patient or the patient's representative, on written request from the healthcare team, as appropriate and commensurate with the medical or physical limitations or disabilities of the patient. That's already in the rule, that there needs to be a reason to do the outpatient or in-home consults. And again, I think this is a good first step to defining this practice and regulating it. There's no reason you can't go further if it turns out there is abuse. This is something that is tracked by our enforcement, and if there are complaints of people abusing that, if we have violations, then we can look at tightening that up in the future if need be. So I did not recommend any changes to the rules at all, except that we've agreed on adding test fitting and the word inpatient in that heading. So if you want to discuss, making any further changes, then this is the time to do that.
Catherine Mize, I'd like to ask you guys one more question, just so it's on public record. On page 2 of the highlighted handout, where we're discussing the written request, and if at this point we're leaving it open to the healthcare team for the inpatient person, do you think it is necessary, if somebody asks me to come in and do a consultation and visit with the patient, I'm not going to cast that patient for anything. I'm not going to take any further steps. I'm not even going to put a shrinker on that patient unless I have an order for a shrinker from the doctor. So that's my understanding.
That's how I practice.
Okay. Do you think it is necessary to include the bolded comment, it's kind of the last yellow highlighted section, that says no further actions to include but not limited to? Do you think we should include that to make it crystal clear to people? You need to have a written request and don't do anything beyond that unless you've got a clear order?
That would require another, that would be something that would have to be put out for comment
I'm not
also.
sure. I'm not sure about that. Laura can clarify that for us in a minute. But aside from that point, do you think it is something necessary?
I don't think it's necessary, because most of us, Sterling Phillips, most of us are not going to do anything unless it's written in that order anyway.
Right.
Most of us, you're right, but we're not talking about us. We're talking about the people that are going too far, that are abusing. Do we need that there to
No, because we're not going to stop
them?
that anyway. It's not going to happen. And
Kevin Matthews.
I think we're just tying our own hands when we keep adding.
I think when we're doing a procedure in an inpatient facility and we don't have a written order from a physician, I think that that's a bad thing. I think it's something that we shouldn't do, personally.
So do we?
In our own office, it makes sense. We have everything we need there. But if you have someone you call a prosthetist in to evaluate the fit of the patient's current prosthesis, and the patient's wearing 20 plies of socks and it's still loose, that doesn't give you the right to go ahead and cast that patient for a new leg. It's basically, they're asking for your recommendation. I don't think in an inpatient facility that we should perform any procedure without a written order. That's my opinion.
Correct. And so do we have the rules and do we have the teeth in place that if somebody violates that, we can go after them?
I don't think so.
Then what good is the rule?
Well, we would have to put it out for comment there and state that in an inpatient situation, no procedures may be performed other than consultation without a written order. Doesn't necessarily detail it.
What if we define consultation?
I think procedure, you just don't do a procedure.
Well, I'm wondering why you feel like if the person's an inpatient, the rules change and it's more restrictive on the practitioner. Because, you know, in the beginning of this section in A, the person can walk in off the street into a facility and you can cast them, you can measure them, you can do those preliminary things. But then you're saying if they're an inpatient, you can't do any of that without an order. So it's inconsistent in the rule if you're more stringent on people that are inpatients, unless there's some reason why you want to be more stringent. And, you know, it's not in the rules, but you can't discount what the hospital or the facility allows either. If they don't let you go in there and do those things, then it doesn't matter what our rules say if they're going to prevent it. But why is there a reason not to do the preliminary steps in an inpatient setting if it's allowed without the order in your hand yet, when it's okay to do it as in an outpatient facility?
Miguel Mojica, that's, in looking at this, that's exactly what I'm seeing a conflict in. Because the scenario isn't that different. If we're allowing outpatients for practitioners to take measurements without an order, then it should be allowed with inpatient, unfortunately. I say unfortunately because I know what we're trying to guard against, but.
I agree. Strike what I said. It's too confusing. It is, it's too confusing.
Well, that slippery slope follows even with what we're allowing to be done as an outpatient. That's why before, we never wanted to allow that without the order.
Right, before, the rule always was you can't cast a patient, measure a patient, period, until you had the order.
So do we want to send this back for reconsideration?
I would say no.
No, and even if it went to reconsideration, it would fail, because if we can do it as an outpatient in our clinic, it would be too difficult to, like you said, why is it different? To me, I feel it is, but that's what you just said, kind of blew that out of the water, so.
Well, in your experience, the hospitals and inpatient facilities frown on you coming in there and doing the measuring and casting, or do they just not care, or, you know?
I never do it without an order, so I would go in and do a consult, but I would never take the mold. I don't show up with my casting bag if they just want me to come in and look at the patient and make a recommendation. I would go back and mold,
So the rule may be superfluous anyway if you get more stringent, if you're not doing it anyway in an inpatient setting. But it would be inconsistent to be more stringent in that setting, I think.
If we restricted the inpatient setting, then it would also, I think, fall that, well, why, if you can't do it, if they're an inpatient, then you shouldn't be able to do it. So I like it the way it is and not change that.
So I guess we can just wait and see if it becomes an issue?
Correct.
If
Yes.
complaints
That's mine.
arise out of it?
That's mine.
Agreed.
Okay.
But we all know where you're coming from.
Yeah.
Yes,
Okay, thank you.
we do.
Okay, well, you know, if there's anything else you want to talk about or ask about, as far as the text changes, we have just those two changes, the test fitting and the inpatient, adding that word in the heading. If you want to discuss anything further, that's fine. If not, you need to vote to send these to the commission for adoption, and you need to identify yourself who's making the motion and seconding for that.
Should we
So
go
do I-
through these, or?
So do I hear a motion to?
Was that a motion with the few little tweaks?
Right, with the addition of the word test and the removal of the word diagnostic in 114-175 E1, and the addition of the word inpatient in 114-175 A2 in the heading.
So do I hear a motion?
Randy Duncan, motion to send the rules for adoption to the commission.
Do I hear a second?
Sterling Phillips, motion to accept Randy's motion.
So all in favor?
And I accept your motion to accept.
Thank you, sir.
Aye.
I'll give you credit, Red.
All in favor?
Aye.
Aye. All against? So moved. Thank you. So the next item on the agenda is recommendations for agenda items for next board meeting. Anybody have any? Nothing for the
I have nothing.
agenda?
If we, Mary Winston, again, as always, if we don't have anything today, if you all have something before the next meeting, notify advisory.boards. And we, of course, would have staff reports, and I can't think of any other pressing issues. You all have just done a lot of work, so we can leave that open for now.
Okay. Next item is going to be discussion of date, time, and location of the next board meeting.
Mr. Chairman, Nick Bowinas, we don't have a proposed date at the moment for the next meeting, but Christine will be getting with you guys.
So we want to postpone that.
We'll hold off.
You'll give us
You'll
some
hear from
dates, and then we'll pass them out. Okay.
Great, thank you.
Okay. And then do I have a motion to adjourn?
Evan Matthews, motion to adjourn.
Do I have a second?
Randy Duncan, second.
All in favor?
Aye.
All against? So moved. Thank y'all very much.